We are reading Indian Constitution. If we are not aware about what preamble is, then reading of Constitution has no sense at all. Preamble is known as the very soul, very heart of the Indian Constitution, and therefore it holds a very important part in our Indian Constitution. So in today's video, we are going to understand what preamble is, what it is important in the Indian Constitution, and so on. So let's get started. So let us first read the paragraph which I'll be explaining in the simplest way possible. The American Constitution was the first to begin with a preamble. For the first time, the America had introduced the very concept of preamble. And as we all know, our Indian Constitution is a borrowed bag. That means we have been borrowing concept from various different countries and their constitution. And like that, we have also derived the very concept of preamble from American Constitution. Many countries, including India, followed this practice. So America started this routine or started this practice, and later various countries, by seeing America, had adopted the very feature in their constitution itself. The term preamble refers to the introduction or preface to the constitution. So basically, when we talk about preamble, it's basically a, a preface or prastavna. That is what that means. It summarizes the whole concept or whole a book. If we are reading a particular book, be it any book, whatever the author conveys in the whole book, all that has been summarized in the very first page itself. That is known as preface. And if we understand it in Indian context, Indian constitution context, that it is known as the preamble of Indian constitution. It contains the summary or essence of the Constitution, which I have just said. And K. Palkhiwala, an eminent jurist and constitutional expert, called the preamble as the identity card of the Constitution. So, if we are preparing a note on preamble, or if you are answering a particular question on preamble, if we can add certain remarks given by particular jurist or famous figures, that it is possibility we can score good marks. As you can see, these points you can add in the very beginning of the answer. The preamble to the Indian Constitution is based on the objective resolution drafted and moved by Pandit Nehru and adopted by the Constitution Assembly. So before the preamble, it was based on that objective resolution given by Jawaharlal Nehru. It has been amended by the 42nd Constitutional Amendment Act 1976, which added three new words: socialist, secular, and integrity. So 42nd Constitutional Amendment Act is also known as mini constitution, because through this amendment various changes has been made, and also in the preamble some words has been added, that is socialist, secular, and integrity. So this is the very text of preamble, which says the preamble in its present form reads: we the people of India, that means we, the very citizen or the very people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens. So it is our very duty to follow all this following: justice in social, economic, and political, liberty of thought, expression, belief, faith, and worship, which is talking about Article 19, equality of status of opportunity, that means Article 16, which talks about opportunity of employment, and to promote among all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves the Constitution. So it is the very date from when the constitution has been adopted. As I said, the preamble is nothing, just the summary of the whole constitution. Whatever the constitution has written it, the preamble has summarized it in a kind of paragraph. So that is all about the main text. So let us understand ingredients of the preamble. So when we prepare a certain meal or a certain curry, so there are ingredients that has been added in order to make it flavorful, tasty, and like that. So just like that, the preamble has also certain ingredients in it. So now we will be understanding what that is. The preambles reveal four ingredients or components. So it has basically four in total. Source of authority of the Constitution, that means the preamble states that the Constitution derives its authority from the people of India. So the people of India have the authority here. Nature of Indian state. So the preamble also says what would be the nature of state. It declares India to be of a sovereign, socialist, secular, democratic, and republic polity. So this is the very nature of a state. or the constitution or the preamble said a nation should be like this. Objective of the constitution. It specifies justice, liberty, equality, and fraternity as the objective. So it is the very objective of the preamble. Date of adoption of the constitution. It stipulates November 26, 1949 as that is. This is the very uh, key text that we have derived from this previous era, from the exactly what preamble says. From that we have extracted this point. Keywords in the preamble. So let us have a quick look on the keywords that the preamble consists of. Certain keywords: sovereign, socialist, secular, democratic, republic, justice, liberty, equality, and fraternity are explained as follows. So these are the very simple words that we all are familiar with, but we will be understanding this in the context of Indian Constitution. Sovereign. The word sovereign implies that India is neither a dependency nor a dominion of any other nation, but an independent state. It says that India is an independent state. No one has their authority over India. India works as an independent body. There is no authority above it, and it is free to conduct its own affairs, both internal and external, and it is free to do anything it wishes, anything it feels that is good for the development of the country, it is good for the people of India. Though in 1949, India declared the continuation of her full membership of the Commonwealth of Nations and accepted the British Crown as the head of the Commonwealth, this extra constitutional declaration does not affect India's sovereignty in any manner. As we all know, earlier we used to live under British rule, and it is what some quick historical background of India. Further, India's membership of the United Nations Organization UN also in no way constitutes a limitation on her sovereignty. We are a member of UN, but that doesn't mean that they have a power over us. We are sovereign in nature. Being a sovereign state, India can either acquire a foreign territory or could cede a part of its territory in favor of a foreign state. So, being a sovereign, we have this power. Next, we have socialist. Even before the term was added by the 42nd Amendment Act in 1976, the Constitution has had a socialist content in the form of directive principle of state policy. So this point is important to remember. Before 42nd Amendment Act, this particular word was not added in the preamble, though it was in the mind of the framers of the Indian Constitution, but it was not added directly in the context of a word. After 42nd Amendment Act, this has been added. In other words, what was hitherto implicit in the Constitution has now been made explicit. Moreover, the Congress party itself adopted a resolution to establish a socialist pattern of society in its hour decision as early as in 1955 and took measures accordingly. Notably, the Indian brand of socialism is a democratic socialism. So we have democratic socialism in our country and not a communistic socialism. So there is a difference between what is democratic socialism and communistic socialism, also known as the state socialism. So this is another nickname of that socialism, which involved the nationalization of all means of production and distribution and the abolition of private property. Democratic socialism, on the other hand, holds faith in a mixed economy where both public and private sectors coexist side by side. So this is basically the very definition of what democratic socialism is. What are the ingredients that would be fallen under this very concept? As the Supreme Court says, democratic socialism aims to end poverty, ignorance, disease, and inequality of opportunity. So this is the very sayings of the Supreme Court. In order to uh, delete all kind of poverty, inequality, disease, this kind of pattern is needed in our country. Indian socialism is a blend of Marxism and Gandhianism, leaning heavily towards the Gandhian socialism. So it is a mixture of both Marxism and Gandhism theory, but we have more inclined towards Gandhian theory. Now let's move into this. The new economic policy 1991 of liberalization, privatization, and globalization has, however, diluted the socialist dreams of the Indian state. So this is the very state after the new economic policy in the year of 1991. Then we have the word secular. The term secular too was added by the 42nd Constitutional Amendment Act of 1976. So before this word was not mentioned in the preamble, later it came after this particular amendment. However, the Supreme Court said in 1974, although the word secular state were not expressly mentioned in the Constitution, there can be no doubt that Constitution makers wanted to establish such a state and accordingly Article 25 to 28 guarantees the fundamental right to freedom of religion have been included in the constitution. So before, as I said, a very particular word was not exactly written. But if we see from Article 25 to 28, which talks about the fundamental rights to freedom of religion, it somehow conveys the very thinking of the framers of the constitution that they want India to be a secular country. The Indian constitution embodies the positive concept of secularism. For example, all religions in our country, irrespective of their strain, have the same status and support from the state. As I said, India is an amalgamation of many religions, be it Sikh, be it Buddhism, be it Mohammedans, be it Hindus. That's why we are considered to be a secular country, and it is our very duty to uh, keep our brotherhood amongst us, to have faith and to have love for all, despite the religion they follow. Next, we have democratic. A democratic polity, as stipulated in the preamble, is based on the doctrine of popular sovereignty, that is, possession of supreme power by the people. Democracy is of two types, that is, direct and indirect. So, this is the very separation of democracy. In direct democracy, the people exercise their supreme power directly, as is the case of Switzerland. So, this is the very example that is given, that how direct democracy implies of the country, which is alike to Switzerland, or what happens in Switzerland. But in India, we have different kind of system. There are four devices of direct democracy, namely referendum, initiative, recall, and plebiscite. So there are the ingredients or types of direct democracy. In indirect democracy, on the other hand, the representatives elected by the people exercise the supreme power and thus carry on the government and make the law. So this is indirect democracy that happens. This type of democracy, also known as representative democracy, is of two kinds, parliamentary and presidential. So this is the kind of differences, or this is the status of Switzerland or in other countries, that they follow a different kind of democracy, that is direct democracy. The Indian constitution provides for representative parliamentary democracy, under which the executive is responsible to the legislature for its policies and actions. As I said, India follows a different kind of system. We, the people of India, choose our representative and they represent our issues in the very assembly. Universal adult franchise, periodic elections, rule of law, independence of judiciary, and absence of discrimination on certain grounds are the manifestation of the democratic character of the Indian polity. So these are the very character of our system, of our policy, that is independence of judiciary. The judiciary is independent. They can ask the government if they go wrong in any way. We have this rule of law, we have our people, we have this periodic timetable that every 5 year the representative has to answer the people whether they have achieved the kind of development they were talking about or not. So this is the very thing that we follow in our country. The term democratic is used in the preamble in the broader sense, embracing not only political democracy but also social and economic democracy. So when we talk about democratic or democracy, our India follows a wider concept. This dimension was traced by Dr. Ambedkar in his concluding speech in the Constituent Assembly on November 25, 1949, in the following way. So, this is the very text, or this is the very speech given by Dr. Ambedkar. Political democracy cannot last unless there lies at the base of it social democracy. What does social democracy mean? So, he also defines what social democracy is. It means a way of life which recognizes liberty, equality, and fraternity. This principle of liberty, equality, and fraternity are not to be treated as separate items in a trinity. So he says that they are not separated from each other. What are they? That is liberty, equality, and fraternity. If they, go separate from each other, then there is no point in having all kind of good things in our very constitution. They form a union of trinity in the sense that to divorce one from the other is to defeat the very purpose of democracy. So they hold, or they keep the democracy intact altogether. Liberty cannot be divorced from equality, equality cannot be divorced from liberty. So all they are, tied together. One cannot leave each other. Otherwise, the democracy, the very concept of democracy will fall apart. Nor can liberty and equality be divorced from fraternity. Without equality, liberty would produce the supremacy of the few over many. Equality without liberty would political individual initiative. He also explained that what would happen if they all the three aspects or key features separated from each other, then what will be the consequences. So these all have been mentioned by Dr. Ambedkar in his concluding speech in the Constituent Assembly. In the same context, the Supreme Court observed in 1997 that the Constitution envisions to establish an egalitarian social order, rendering to every citizen social, economic, and political justice in a social and economic democracy of the Bharat Republic. So, this is the sayings of Supreme Court. So, the best thing about Indian polity is it includes various remarks from various eminent figures from the decision of Supreme Court, which if we add in our answers, that can give us good marks. Next, we have the Republic. A democratic polity can be classified into two categories. Again, we can divide Republic into two categories. That is monarchy and republic. So we all know what monarchy is, where the king and the queen rules like Praja and Raja kind of concept. But in India, we don't have such kind of concept. And in a monarchy, the head of the state, usually king or queen, enjoys a hereditary position. That is, he comes into office through succession. For example, Britain. So this is the example that has been given that they come from a hereditary procedure. If the king is being the head of the state, then after his demise, his child would take the position. After that, his child would take the position. So that's how the monarchy system works. In a republic, on the other hand, the head of the state is always elected directly or indirectly for a fixed period, for example, USA. But what we have in republic system, the people select the head of the state through an direct or indirect method of election. Therefore, the term republic in our preamble indicates that India has an elected head called the president, because the president is elected by the representative. It is not that he is coming from monarch system, he is elected. He is elected indirectly for a fixed period of 5 years. So this is the fixed term that he will be elected for. The republic also means two more things. One, vesting of political sovereignty in the people and not in a single individual like a king. Second, the absence of any privileged class and hence all public offices being open to every citizen without any discrimination. So this is also the very reason why India follows a republic kind of system. Then we have justice. The term justice in the preamble embraces three distinct forms: social, economic, and political, secured through various provisions of fundamental rights and directive principles. So, through the medium of FR, fundamental rights, and directive principle of state policy, we have justice. That is justice for both in economical sector, in political sector, and social sector as well. Social justice is a very definition of what social justice is. Social justice denotes the equal treatment of all citizens without any social distinction based on caste, color, race, religion, sex, and so on. So this is basically talking about Article 15, which prohibits any kind of discrimination on any ground. It means absence of privilege being extended to any particular section of the society and improvement in the conditions of backward classes, which is SC, STs, and OBCs and women. It says that no person will be treated in a privileged manner. Everyone should be treated equally in the eye of law. Economic justice denotes the non-discrimination between people on the basis of economic factors. It involves the elimination of glaring inequalities in wealth, income, and property. Combination of social justice and economic justice denotes what is known as distributive justice. So this is basically the very definition of what economic justice is. Then we have political justice. Implies that all citizens should have equal political rights, equal access to all political officials, and equal voice in the government. It is the right to vote. Everyone has the right to vote despite their status. The ideal of justice, social, economic, and political has been taken from the Russian Revolution. Again, this very concept we have derived from the Russian Revolution, that is 1917. This can come as an MCQ. So this is very important to note down this thing. Then we have liberty. The term liberty means the absence of restraints on the activities of individuals and at the same time providing opportunities for the development of individual personalities. So the sentence sounds tough, but basically it says liberty means a person has all kind of freedom to do anything he or she wishes. That is what liberty means in its contextual term. Now, what about the Indian Constitution? What it says regarding liberty. The preamble secures to all citizens of India liberty of thought, expression, belief, faith, and worship, So their fundamental rights enforceable in court of law in case of violation. So this is basically talking about Article 19, which gives us certain freedoms regarding to freedom of movement, freedom to carry trade, freedom to uh, speech and expression. But along with that, we have certain exception also. And what is the very reason of his exception? Because a person cannot have absolute liberty, then he or she can do anything he wishes, which will not be good for the society. In order to curtail that abusive of liberty, certain exception has been added in our very Indian constitution. Liberty is elaborated in the preamble is very essential for the successful functioning of the Indian democratic system. So it is very essential to have in a democratic system. However, liberty does not mean license to do what one likes, and one has to be enjoyed within the limitation mentioned in the constitution itself. As I said, Article 19 talks about both the freedoms as well as the exception also, because it is important to curtail when the power goes in a abusive hands or works for the bad of the society. In brief, the liberty conceived by the preamble or fundamental right isn't absolute but qualified. I said they are not absolute, they are qualified. They have certain limitation on it. The ideals of liberty, equality, and fraternity in our preamble have been taken from the French Revolution 1789 to 1799. So this is again from where we have taken the very concept of liberty. So till now we have got 3 points. One, the very concept of preamble has been taken from USA. Then we have taken this justice from Russian Revolution. Then we have taken liberty from French Revolution, which is very important to note it down. Then we have equality, which is Article 14, which talks about equality before law and equal protection of law. The term equality means the absence of special privileges to any section of the society and the provision of adequate opportunities for all individuals without any discrimination. So it basically denies that there is no specific privileges for any person, all should be treated equally. The preamble secures to all citizens of India an equality of status and opportunity, that is Article 16. This provision embraces three dimensions of equality, that is civic, political, and economic. The following provisions of the chapter on fundamental rights ensure civic equalities. Article 14, that is equality before the law. Then we have Article 15, which talks about any kind of prohibition should be prohibited. Then we have equality of opportunity, Article 16. That we have untouchability, Article 17. That we have abolition of title in Article 18. There are two provisions in the Constitution that seek to achieve political equality. One, no person is to be declared ineligible for inclusion in electoral rolls on ground of religion, caste, race, caste, or sex. That is Article 325. Two, election to Lok Sabha and the state assemblies to be on the basis of adult suffrage. That is Article 326. So, if the preamble says that everyone should be treated equally, they should be treated equally. And in order to make that promise, worthy, there are very articles we have in our very constitution, including Article 325 and 326. The directive principle of state policy, Article 13, secure to man and women equal right to an adequate means of livelihood and equal pay for equal work. Then we have fraternity, that means a sense of brotherhood. The Constitution promotes this feeling of fraternity with a system of single citizenship. So India provides a single citizenship only. There is no other citizenship for state. For example, if I am from Assam, I do not have a separate citizenship for my state only. Everyone has to get only one particular citizenship, that is we are the citizen of India only. There is no state mentioned, and that's what brings the brotherhood among us. So wherever. Also, the fundamental duties, Article 51A says that it shall be the duty of every citizen of India to promote harmony and the spirit of common brotherhood among all the people of India, transcending religious, linguistic, religion, and sectional diversity. So, the very reason of having single citizenship is to bring all the people together so that they have love for each other, they have the feeling of brotherhood towards each other. The preamble declares that fraternity has to assure two things, the dignity of the individual and the unity and the integrity of the nation. So these 2 points you can write separately, and the headline would be the preamble declared that fraternity has to assure two things. And what are the two things? These two is the two things. The word integrity has been added to the preamble by the 42nd Constitutional Amendment 1976. So it has integrity is also added later by the 42nd Amendment Act. According to K.M. Munshi, a member of the drafting committee of the Constitution Assembly, the phrase dignity of the individual signifies that the Constitution not only ensures material betterment and maintain a democratic setup, but that it also recognizes that the personality of every individual is sacred. So this is the sayings by K.M. Munshi, a member of drafting committee. So all these remarks you can add if you want to. This is highlighted enough some of the provisions of the fundamental rights and directive principle of state policy, which ensure the dignity of the individual. Further, the fundamental duties, that is Article 51A, also protect the dignity of women by stating that it shall be the duty of every citizen of India to renounce practices derogatory to the dignity of women, and also makes it the duty of every citizen of India to uphold and protect the sovereignty and integrity of India. So this is the very duty of all the citizens of India. The phrase unity and nation embraces both the psychological and territorial dimension of national integration. Article 1 of the Constitution describes India as a union of states. So it is a unity among all the states under India. To make it clear that the state have no right to secede from the union, implying the indestructible nature of the Indian Union. It aims at overcoming hindrances of national integration like communism, regionalism, casteism, linguism, secessionism, and so on. So we are in this together. We are a unity. We are not separate. You are from you are from this state. You are from this state. So there is no such separation. So now let's move into the significance of the preamble. The preamble embodies the basic philosophy and fundamental values, political, moral, and religion, on which the Constitution is based. It contains the grand and noble vision of the Constitution Assembly and reflects the dream and aspiration of the founding fathers of the Constitution. So, very significance of the preamble, it is basically says that what the father or founders of Indian Constitution has thought of India. So that is what the significance of the preamble is. In the words of Sir Aladi Krishnaswamy Iyer, a member of the Constitution Assembly who played a significant role in making the Constitution, the preamble to our Constitution expresses what we had thought so or dreamed so long. So you can write separately the remarks given by the various famous figures, and you can also write separately the members from Constituent Assembly. So this way you can easily remember what are the members, what are their remarks regarding to preamble. According to K. M. Munshi, member of the drafting committee of the Constituent Assembly, the preamble is the horoscope of our sovereign democratic republic. So this is another remark given by K. M. Munshi, another member of drafting committee. Pandit Thakudas Bhargava, another member of the Constituent Assembly, summed up the importance of the preamble in the following words. The preamble is the most precious part of the Constitution. It's most precious. For example, just for a person feels for his better half, that he is more precious to me, he is the precious one in my life. So this is what preamble has, like in order, like for Indian Constitution, the preamble is the precious that we cannot let it go from ourselves. It is so precious to us. It is the soul of the Constitution. It is the key to the Constitution. It is a dual setting Constitution. It is a proper yardstick with which one can measure the word of the Constitution. These are the very remarks given by this very particular figure. Sir Ernest Baker, a distinguished English political scientist, paid a glowing tribute to the political wisdom of the authors of the preamble. So he was so inspired by the preamble that he has given tribute to the preamble. He described the preamble as the keynote to the Constitution. He was so moved by the text of the preamble that he quoted in his book that what preamble is. So let's move towards the preamble as part of the question. So this is the $1,000,000 question. So whether preamble is a part of the Constitution or is not, and which, if you are a student of LLB, so this question will come at, like, this is a mass question. It will ask whether preamble is a part of the Constitution and not, and how you need to answer it. You need to refer to the earlier decision or case laws which says that preamble is a part of the constitution, and there are other case laws which also say that preamble is not a part of the constitution. So one of the controversies about the preamble is the whether it is a part of the constitution or not. As I said, it's a very crucial topic, but now the solution has been given. Until now we have stick with that particular answer only. In the Berubari Union case, it is the very first case in this remark in the year of 1960. The Supreme Court said that a preamble shows the general purposes behind the several provisions in the Constitution and is thus the key to the minds of the makers of the Constitution. So it says basically the preamble shows us what the framers of the Constitution had thought of India, and it gives us a kind of light that we need to read the Indian Constitution. Further, where the terms used in unique article are ambiguous, capable of more than one meaning, some existence or interpretation may be taken from the objective enshrined in the preamble. So it says if we are reading some particular article and the very expression is very vague, then we can take help from the very preamble itself, and it will work as a guide in order to make the very article easier for us to understand. Despite this recognition of the significance of the preamble, the Supreme Court specifically opined that preamble is not part of the Constitution. So this is the very exact sentence that we were looking for. That in this particular case, it has been stated that preamble is not a part of the Constitution. It is separate from the Constitution. It provides as a guide to the Indian Constitution. Then we have the famous case, that Kesavananda Bharati case, which is also known as the Fundamental Right case in the year of 1973. The Supreme Court rejected the earlier opinion, held that preamble is a part of the Constitution. So what happened? The Supreme Court has reversed its earlier decision given in the Berubari case and says that yes, preamble is the part of the Indian Constitution, and the decision given in the earlier case was at default. Therefore, we are correcting it in this very case, and held that it observed that the preamble is of extreme importance in the constitution. So if you are saying that the preamble is the soul of the constitution, heart of the constitution, how can you say that it is separate from the very constitution? Should be read and interpreted in the light of the grand and novel vision expressed in the preamble. So this is the decision given in the Kesavananda Bharati case. Then we have LIC of India case in the year of 1995. Also, the Supreme Court again held that the preamble is an integral part of the constitution. Again, preamble uh, said to be part of the Constitution. Like any other part of the Constitution, the preamble was also enacted by the Constituent Assembly. But after the rest of the Constitution already enacted, so preamble was added at last after finishing the very document of the Indian Constitution. Then the preamble uh, came in presence, came in physical form. The reason for inserting the preamble at the end was to ensure that it was in conformity with the Constitution adopted by the Constituent Assembly. This is the very reason why we, or the Constituent Assembly members, have added the preamble at last, so that whatever the Indian Constitution consists of, the preamble can summarize them all. While forwarding the preamble for vote, the President of the Constituent Assembly said the question is that preamble stands part of the Constitution. The motion was then adopted, hence the current opinion held by the Supreme Court, the preamble is a part of the Constitution, is in consonance with the opinion of the founding fathers of the Constitution. So after that Kesavananda Bharati case, it has been answered as that preamble is a part of the Constitution. However, two things should be noted. The preamble is neither a source of power to legislature nor a prohibition upon the powers of legislature. It is not justiciable. It is its provision are enforceable in court of law. The preamble says if you can understand whatever is written, if you can follow whatever is written, be it fraternity, brotherhood, integrity, it is very good. But if you can somehow cannot able to abide by this, then also it is non justiciable in nature. That means these provisions are not enforceable in the courts of law. They are not mandatory or compulsory. It is for you to follow by using your own conscience. Then you have amendability of the preamble. The question as to whether the preamble can be amended at Article 68 of the Constitution arose for the first time in the historic Kesavananda Bharati case. So this case you have to remember at any cost, because in every question it will be coming up again and again and again. It was urged that the preamble cannot be amended as it is not a part of the Constitution. So in this very case, the famous doctrine, the basic structure doctrine, has been established, and there are some of the part of the Constitution which has been added in this basic structure doctrine, which is preamble is also a part of the basic structure doctrine. The petitioner contended that the amending power in Article 368 cannot be used to destroy or damage the basic elements of the fundamental features of the Constitution which are enshrined in the preamble. So Article 368 basically talks about the amendment procedure. It says that a parliament can amend anything despite the basic structure theory, and under the basic structure we have certain parts of the Indian Constitution, be it the preamble, be it the rule of law, be it the independence of judiciary. There are various points that have been added into the basic structure theory. The Supreme Court, however, held that the preamble is a part of the Constitution. The court stated that opinion tendered by it in the Berubari Union 1960 in this regard was wrong, and held that the preamble can be amended subject to the condition that no amendment is done to basic features. So as I said, Supreme Court later said the Berubari case was wrong, therefore it was corrected in the Kesavananda Bharati case. In other words, the court held that the basic elements of the fundamental features of the Constitution as contained in the preamble cannot be altered by an amendment under 368. So it is strictly prohibited that Parliament cannot amend the preamble at any cost. The preamble has been amended only once so far in 1976 by the 42nd Constitutional Amendment Act. So for the first time only in the history, the preamble has been changed or amended, and it has added certain words, that is socialist, secular, and integrity preamble. This amendment was held to be valid. Other than that, there is no change that has been made to the preamble. So this is all about what preamble is. Hope I made it worth watching. If you find this video valuable, if you want me to bring more such articles in the simplest manner possible, do like, share, and subscribe so that I get motivated to bring such concept. So that's all about today. Thank you for watching the video.